Greetings everyone. Today I want to talk to you about the 6 rules to remember if you are driving drunk and get stopped by the police. I mean, imagine this scenario. It's late at night, you're on your way home, you've had a few drinks, maybe one too many, but you've made it across town and your house is just around the block. But then you get a text or a phone call and you look down at your phone, and the next thing you know, you're getting pulled over. What do? You've had a few drinks, probably way too many, and you've only got a few seconds to collect yourself. So what do? Hi, my name's F.T. Sessoms. I'm a Minnesota DWI and criminal defense lawyer. I've been defending people for over 30 years, and in this video, I will discuss with you the 6 rules I would like to see a client follow whenever that person gets pulled over in Minnesota for drunk driving. I'm giving you a defense lawyer's perspective because one of the duties of an attorney is to educate the public as to their rights and responsibilities when they encounter the police. In other words, to tell you what you can do within the rules to assist with your defense when you get caught. So don't blow up on me. So don't blow up on me saying I'm encouraging drunk driving, because I'm not doing that in any way, shape, or form. Take a cab, or an Uber, or a Lyft, or have a designated driver, or just stay home. No, what I am doing is discussing with you the constitutional rights that you have in your encounter with the police, and how you should exercise the rights that you've been given to aid in the defense of your case. And if you have an issue with that, well, perhaps you might like to take out your money and yell at George Washington, or yell at Alexander Hamilton, or even Ben Franklin. You know, our founding fathers, the people who gave us these rights in the first place. I'm just the messenger here, so let's get started. Rule number 1, be polite. The Minnesota State Patrol and virtually all police departments have equipped their officers with body-worn cameras. So when they walk up to your car, how should you behave when you're now the star of the show? Well, it's been my experience that juries try to do the right thing. And like most people, juries want to help people that they like, or they want to help people that they do not hate. So if you're calm and polite throughout your encounter with the police, the jury is not likely to hate you. So never say anything like, my taxes pay your salary, and I'm going to have your badge, or my lawyer's going to rip you a new one, because A, the judge or jury is going to hate you, and B, if you are calm and polite, you will greatly decrease the likelihood of a physical or verbal confrontation with the officer. Remember that when the officer is walking up to your car, he doesn't know if he stopped a soccer mom or a stone-cold killer. So the police officer might be a little bit nervous, just like you. So put your hands on the wheel where the officer can see them and be calm and polite. And what's the best way to be calm and polite? Well, that leads me to rule number 2. Keep your mouth shut. You've been caught. You are drunk. But you don't have to implicate yourself, so don't do it. And the way not to do it is to keep your mouth shut. When you are stopped for a traffic violation in Minnesota, you are required to provide the police with 2 things: your driver's license and proof of insurance. That's it. And any conversation beyond those 2 topics is potentially harmful to your defense. The officer will typically ask you for your license and insurance, and if he suspects something more, he will begin to question you, begin to talk to you. Where are you going? Where have you been? I smell alcohol. How much have you had to drink tonight? Now, you've been stopped for a traffic violation. It's an inherently dangerous situation, both for you and for the officer to be sitting there by the side of the road. So if the officer is only interested in issuing a ticket, he will not stand around and engage in idle chit-chat. But when the officer starts to question you, they're not there to engage in idle chit-chat. They are questioning you to get you to make admissions. I was at the bar all night, but I only had 2 beers. Yeah, well, that's helpful because it locks you in as a liar when your alcohol test comes back at twice the legal limit. And if your attorney needs you to testify at a pretrial hearing or at the trial itself, you've already impeached yourself, and the prosecution gets to argue that you're just not a credible person. Remember, you never have to talk to the police. So please stop talking as soon as the officer goes beyond asking about your license or insurance information. Now, when the police start to question you about your drinking or activities, you can't just say, I don't want to talk to you, or I'm not talking to you, because the law is that in order to stop the police from questioning you, you must unambiguously notify them that you are invoking your constitutional right to remain silent. Telling the officer, I'm not talking to you, or I don't want to talk to you, or simply remaining silent is not going to cut it. You have to say, Officer, I am not talking to you as I am invoking my Fifth Amendment constitutional right to remain silent. In fact, you don't even need to remember the amendment number. Just saying, Officer, I'm invoking my constitutional right to remain silent should be sufficient. And keep repeating that statement if the officer persists in asking you any questions. It has been my experience that some officers think the right to remain silent only applies after the person has been placed under arrest. But that's not true because the Fifth Amendment protects you from police questioning at any time. So as soon as the officer asks you a single question that does not pertain to your name, address, or insurance company, notify the officer that you are invoking your constitutional right to remain silent. And what does that accomplish? Well, number one, it cuts off the officer's ability to question you to get you to say something stupid. And number two, the conversation where you assert your right to remain silent is not admissible in court, so the jury does not get to see or hear you say any of that. The next thing that is going to happen is that the officer is going to ask you to get out of your vehicle, which brings me to rule number 3. Get out of your vehicle when you're told to do so by the police. Now you may be saying to yourself, hey, wait a minute. I was pulled over for having a taillight out, or for failing to come to a complete stop at a stop sign, or for having expired tabs. Why should I have to get out of my vehicle, as that seems like an unnecessary escalation of the situation? And logically speaking, you may be right. The problem, though, is the law is not on your side. The United States Supreme Court, the Minnesota Supreme Court, and the Minnesota Court of Appeals have all said that if you've been pulled over for any traffic stop, the officer can order the driver and the passengers out of the vehicle. Now, you may believe your stop is bogus. You may feel you're being harassed. You might think you're being targeted by the man. But the streets of Minnesota are not where we litigate the validity of your stop or the validity of your arrest. And it doesn't do you any good to get in a verbal or physical confrontation with the officer. Now, I've included a YouTube link down below showing what happened to professional football player Tyreek Hill of the Miami Dolphins, who refused to roll down his window or get out of his car after being stopped for speeding. The video shows the police hauling Mr. Hill out of his vehicle. They put him on the ground and then they handcuff him. And you can find dozens of other videos showing the exact same thing. Whenever a person refuses to get out of their vehicle, things can and will go sideways really, really fast. Remember, the law on this is on the side of the police. So when you're told by an officer to get out of your vehicle, just do it. Once you're out of your vehicle, remember rule number 4. Do not take the field sobriety test. After you are out of your vehicle, the officer will ask you to take some field sobriety test. But the officer will never say something like, will you please take some field sobriety test? Instead, the officer will say something to you like, I'm going to give you some field sobriety tests to make sure you are good to drive or good to go. So come over here and let's get started. The officer does not tell you that these field sobriety tests are optional because the Minnesota Court of Appeals has said that they don't have to tell you. But in this situation, ignorance is not bliss. Now the police make it sound like you have to take the test to make sure you are good to go. So the question is, should you ever take these optional field sobriety tests? And the answer is no, No, no. Now you may be saying to yourself, well, won't I look bad on camera if I refuse to take the field sobriety test? And the answer is no, not if you do it right. You must refuse in the correct manner. Just saying, no, I'm not taking them, or no, I don't want to take them, or no, I refuse to take them, is not going to cut it. Because remember, just like when you invoked your constitutional right to remain silent, you have the duty to notify the officer that you are invoking your constitutional right to refuse to submit to a warrantless search or seizure. So the A+ answer would be to say, officer, I'm asserting my constitutional right under the Fourth Amendment to the United States Constitution and Article 1, Section 10 of the Minnesota Constitution not to submit to your warrantless search or seizure. But of course, you're not going to remember all that because you're drunk. But you should be able to remember to say, officer, I'm asserting my constitutional right to refuse to submit to your warrantless search or seizure. It is not illegal to refuse to submit to the field sobriety test in the state of Minnesota. Now, I can't speak for other states. I do not speak for other states. But in the state of Minnesota, it is within the rules to refuse to submit to these optional field sobriety tests. And when you notify the police that you're refusing, not because you don't feel like taking them, but because you are asserting your constitutional right to be free from a warrantless search or seizure, the prosecution cannot introduce evidence of your refusal to take the test at your trial. Or as stated by the federal courts and the Minnesota Supreme Court, it is a violation of the defendant's right to due process for a prosecutor to comment on a defendant's failure to consent to a warrantless search. Now, the state may argue that they want to introduce evidence of your refusal to take the field sobriety test because the Minnesota Court of Appeals has said that a roadside field sobriety test is not a search within the meaning of the Fourth Amendment. But the Court of Appeals statement in that case is what I call a non-answer answer, because the Fourth Amendment does not just protect against warrantless searches, it also protects against warrantless seizures. And the Minnesota and the United States Supreme Court have repeatedly said that there's no constitutional distinction between a warrantless search on the one hand and a warrantless seizure on the other. Vive la no différence. So the question is, do field sobriety tests constitute a seizure? Well, there are 3 standardized field sobriety tests that are approved for use by the National Highway Traffic Safety Administration. There is the horizontal gaze nystagmus test, or the eye jerkiness test. There's the walk and turn test, and there's the one-leg stand test. And let's take a look at what you're supposed to do on the various tests. From the instructor manual on field sobriety testing, when you're asked to do the horizontal gaze nystagmus test, you're told to put your feet together with your hands by your sides. That's a seizure. Keep your head still. That's a seizure. Look at the stimulus and follow the stimulus only with your eyes. Keep looking at the stimulus until the test is over. The second test you'll be asked to do is the walk and turn test. And there they tell you to keep your arms by your side and to place one foot in front of the other and stand in that position until they're done with the test instructions. Not to mention making you walk heel to toe 9 steps up and back with a funny turn in the middle to come back. And the final standardized field sobriety test, the one-leg stand test, is also a seizure, as the officer has you raise one leg 6 inches off the ground, keeping your leg straight, staring at your raised leg, and counting, saying 1001, 1002, 1003, until you're told to stop. Since you have the right to refuse the field test, and you have the right to keep out the evidence of your refusal, both at your trial and during any hearing, which seeks to determine probable cause, then why on earth would you ever submit to the field sobriety test in the first place? Do you think you're going to pass? Well, she thought she was going to pass.
2, 3, 4, 5, 6, 8, 9.
9 steps, yep. Okay.
He thought he was going to pass.
If you put your foot down, go ahead and pick it back up and start again.
1, 2, 3, 4, 5.
Go ahead and start again.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
And even if by some miracle you were to pass the field sobriety test, you can still lose in court. I mean, take a look at this case. In Miesenberg versus Commissioner of Public Safety, a state trooper stopped the driver for speeding. And when the officer came up to the vehicle, the driver smelled of alcohol, but he denied having anything to drink. The trooper suspected the driver might be under the influence. So the officer got the driver out of the vehicle and had him perform the 3 standardized field sobriety tests. The Minnesota Court of Appeals noted in Miesenberg that the state trooper failed to properly administer one of the field tests and that the driver flawlessly performed the other 2 field sobriety tests. But the Court of Appeals said the officer still had a reasonable suspicion because the driver had been speeding, had the odor of alcohol, and had denied drinking. Now, the Court of Appeals could have said that the trooper initially had a reasonable suspicion when he first encountered the driver because the driver had been speeding, had the odor of alcohol, and had denied drinking. But then, when the driver performed flawlessly on the field sobriety test, the Court of Appeals could have said that the trooper's reasonable initial suspicion was dissipated or dispelled by the driver's outstanding performance on the field test. But the Court of Appeals did not say that. Instead, they said that Miesenberg's successful completion of the test may have diminished the suspicion that he was impaired, but it did not completely remove the suspicion. But that's not the standard. The standard is not whether all suspicion is removed. The standard is whether, based upon all the evidence, the officer still had a reasonable suspicion to believe the driver was impaired. And if the driver performs the certified field test almost perfectly or flawlessly, how does a reasonable officer still have that reasonable suspicion? So then the Court of Appeals goes on to say, well, we all know that it's not uncommon for a person under the influence to be able to satisfactorily perform these field sobriety tests. So let me see if I have this straight. On the one hand, when a driver does not satisfactorily perform the test, the courts routinely use the test results to find a reasonable suspicion or to find probable cause to place a person under arrest for DWI. But on the other hand, when the driver doesn't just satisfactorily perform the test, but does them flawlessly, the court goes, who cares? We'll just go with the trooper's first impression. Now, mind you, Miesenberg is a published decision, meaning that the reasoning of the case is binding on all the lower courts. And doesn't their decision sound a bit to you like a case of heads we win, tails you lose? These tests are optional, so don't take them. Because if you assert your constitutional right to refuse the field test, then what roadside evidence will the prosecution have against you at your trial? Well, they will have your driving conduct. They will have you being calm and polite as you hand the officer your license and insurance information. And they will have you getting out of your vehicle. And that's about it. Which brings me to rule number 5. Take the preliminary breath test. After you get out of your vehicle and assert your constitutional right to refuse the field sobriety test, the officer is going to offer to have you blow into a preliminary breath test machine. So the question is, should you take the preliminary breath test? And the answer is yes, absolutely yes. First of all, the preliminary breath test is not generally admissible against you at your trial. The jury never gets to hear about the number. The only time the preliminary breath test result is admissible against you is if you refuse to submit to the evidentiary alcohol test taken down at the police station. When you arrive at the police station, you will be asked to submit to one of three types of evidentiary tests. It will either be a breath test on the data master machine or a blood or urine test obtained pursuant to a search warrant. If you take the test that you were offered at the station, the preliminary breath test result taken at the scene of your stop is not admissible against you at your trial. And even if you refuse the evidentiary test at the station, the preliminary breath test result may not be admissible if the court finds that your particular PBT test result was not foundationally reliable. A preliminary breath test device runs on a fuel cell. Fuel cells are notoriously inaccurate, particularly as they age. Their test results are also affected by heat and cold. So even if you refuse the evidentiary test at the station, there's a chance to keep out the preliminary breath test result as being unreliable. Another reason to take the preliminary breath test is there's a slight chance you might pass. You might be a lightweight drinker after all, and test under the legal limit of 0.08. And if you do pass, there's a chance that the officer may let you go. It has been my experience that even if you do test under the legal limit on the PBT, the officer will often say, well, I think you're under the influence of something, so I want to take you down to the station for further testing. And that's fine, because a test under the legal limit undermines the probable cause that the officer has to place you under arrest in the first place. So be sure to ask the officer for the test result of the preliminary breath test. The officer is not legally required to tell you the result of the preliminary breath test, but often they will. So be sure to ask for the results, as that information is huge for rule number 6. Call a lawyer. In Minnesota, you have the right to talk to a lawyer prior to any breath testing done at the police station. If you know the results of the preliminary breath test, that information is invaluable to any attorney that you call prior to your evidentiary breath test. And you should always exercise your right to counsel prior to testing, as an attorney can properly advise you of the consequences of your testing decision. For example, suppose this is your first DWI arrest, and you know that you blew a .20, or over twice the legal limit, there at the scene of the stop. Should you take the test or refuse? Well, let's take a look at the consequences of that testing decision, as they can be quite different. First-time offender who tests at the police station at .16 or more will be required to post mandatory bail in the amount of $12,000 or go on an alcohol monitor pending the resolution of their criminal case. The first-time offender will lose their license for 1 year, and the offender will not be eligible for a limited license or work permit during that 1-year revocation period. The only way that that person can legally drive during the year is to enroll in an interlock ignition program. And the only vehicle that they're allowed to drive is the vehicle equipped with the interlock ignition device. The license plates of the vehicle used in the offense are impounded, and the driver must get whiskey plates for all the vehicles registered in their name, unless that offender enrolls in the interlock ignition program. Now, the offender does not subsequently receive a reduction of the license revocation period, even if they're only convicted of a lesser charge. On the other hand, if the first-time offender refuses to submit to the evidentiary test at the police station, the offender will also be charged with a gross misdemeanor, but they're not required to post any mandatory bail or go on an alcohol monitor as a condition of release. A court could impose those conditions, but the court is not required to do so. A first-time refusal results in the loss of a person's driver's license for 1 year, but they are eligible for a limited license or a work permit 15 days after the expiration of their 14-day temporary permit. The license plates of the vehicle used in the offense for a first-time refusal are not impounded, and the conviction on the refusal charge cuts the license revocation period from 1 year down to 90 days. If the refusal charge is reduced to 4th-degree DWI or misdemeanor DWI, then the license revocation period is further reduced to 30 days. So as you can see, the consequences are dramatically different for a first-timer who tests at twice the legal limit versus a first-timer who refuses to submit to testing. Now, the police will tell you prior to testing that refusal to submit to the evidentiary test is a crime. And no lawyer that you call on the night of your arrest is going to tell you to refuse to submit to testing, because a lawyer cannot advise a person to commit a crime. But an attorney can advise you of the consequences of your testing decision so that you can make an informed decision for yourself in your particular case. Now, if you like this video, please hit the like and subscribe button. I've told you the 6 rules that I would like to see a client follow whenever they are faced with a drunk driving arrest. But it really just boils down to 2 magic words: constitutional right. Officer, I assert my constitutional right to remain silent. Officer, I assert my constitutional right to refuse to submit to your warrantless seizure. And if you remember those 2 magic words, you will know what to do whenever this happens to you.